So I talk about depositions and being able to do quality depositions being the big thing, the most important thing in your litigation arsenal. But a lot of times it's most important for reasons that most of us don't know. Most of us think that deposition taking and doing a good deposition is when you get information and questions answered and you cover all the bases. And I want to talk about the secret, the unintended benefit of being a good depo taker, of being a good lawyer and appearing to be a good lawyer. So remember, I talk about leopards don't change their spots, and the best group to determine what kind of leopard, what kind of lawyer you are insurance companies. They look at behavior like how soon you go into a deposition. How quickly do you notice the defendant or the PMK's deposition? If you stick with it and you take it, if you don't wait around for objection after objection to documents and you're waiting on documents and you delay 9, 10, 11 months before you take a depo, if you don't make motions to compel. But all of that is the thought of, well, I need to get into a deposition so I can learn the information to win my case. And that's important. But let's talk about the other reasons you want to be in a deposition. And you want to be in a deposition as soon as you can. Sometimes this is more important than the information you get. And then I'm going to give you an example. Right? So remember that depositions are when you're taking under oath testimony. It raises the bar about how people have to act. And there are rules, there's law that apply to how you can conduct a depo, how you can ask questions. But taking a good deposition is only about 30% law, and it's about 70% art. And once you know the basics, once you know that the only objections that can be made are form of the question objections, that under Stewart versus Colonial Western, a defense lawyer cannot instruct a witness not to answer unless it is a question about privacy or privilege. Once you know that depositions are a public proceeding, right? Once you know that multiple people can talk, once you know that you can stand up and ask questions, you can move around and you can ask the deponent to move around. All of that law allows you now to perfect the art of taking a deposition. And the unintended effect of taking a depo, knowing the law, and acting in a way that you know what you're talking about is what the defense lawyer and the carrier think about you when they go back and they write a letter updating about the case. And they don't say, the plaintiff's lawyer is awesome, but they do say, well, the plaintiff's case is pretty good. We're going to need more money, reserves, et cetera. So let me give you an example of something that happened earlier this week. I have a lawyer in the office who was taking a defendant's depo in a clear rear-ender accident. And I was listening in to just get an eyeball of the new defense lawyer I'd never met before and of the defendant, right? So the lawyer for us asked a question like, so you agree you're at fault? And immediately the defendant, who thinks he's holier than thou, clearly comes off as a jerk. It's like, well, what do you mean by fault? And the lawyer in my firm is going into, let me explain to you what fault is, whatever. And I interrupt and I say, hey, if he doesn't know what fault is, then let the jury decide. The defense lawyer interrupts, counsel, only one lawyer can talk in a deposition. Now I know the law. And I said, no, that's not true. The code says that. I'm like, where is it in the code? Well, show me in the code that you can talk. I said, a deposition is a public proceeding. If you want to look it up in CCP 2025. So then I talk to the lawyer again and I say, ask him if he understands what fault means. And then if he says no, ask him, did he do anything wrong? And if not, did the plaintiff do anything wrong? And he goes through that and the guy's like trying to interrupt. And I said, you can't coach. Stop coaching. These are speaking objections. They're not form of the question objections. The defense lawyer, well, you're coaching the lawyer. I'm like, that's totally appropriate. But you can't coach the witness who's under the penalty of perjury. By the way, if you know any of the information, because this is a penalty of perjury, different procedure than if we were just asking you general questions. And by the way, if your client doesn't know what the word fault is, I'm fine with that because the jury's going to know what it is and he's going to look like an idiot. Don't say that. And I'm like, look, I'm just saying it the way it is. I'm going to suspend this deposition unless only one of you talk. I said, no, that's not going to happen. Well, then I'm going to suspend it. I said, go do what you want. By the way, under 2025, you're supposed to allow any of the questions that we can get. I'm not going to do that. I go ahead and do it. So he suspends the deposition. Now, how I look at that, two ways. Oh, I didn't get any information. Oh, I didn't get the answer for him to admit fault. Oh, I had a lot more to know about the accident, et cetera. Well, if we really want that information, we will get that down the road, right? But what have I shown? I know the law. We're not going to take any BS, right? I learned that the defendant is a jerk, that the defendant is not going to admit even basic things, and he probably doesn't want to see me at the trial, right? I also know that they paid attention because there was another depo in that case that happened, and I wasn't in it. And the defense lawyer brought the senior partner to be in the depo too. I assume to try to tell me off or to keep me away or who knows what. Now, I wasn't being a jerk, right? I wasn't being rude. Maybe my voice was up, but I was not saying anything that was a misrepresentation that was wrong about the law. I know what the hell I'm talking about. Now, sometimes you don't win the battle, right? He did not listen to my correct arguments about the law, and he suspended the depo. He's got to do that maybe to save face, maybe to look good, maybe because he doesn't know what he's talking about. He needs to go back and look at the code, but he doesn't feel comfortable enough to say, look, I don't know the answer. Let me take a break and go look. Maybe he's just got his pride hurt. Who knows? But that battle that I may have lost because they stopped the depo is just one battle in a war that we're certainly going to win. And all of that is because we took a depo early in the case, because we knew the law and we pushed. And it had nothing to do with getting information. It had everything to do with telegraphing the type of lawyers and people that we are to the other side. And that case probably is going to settle for a lot of money without a lot more work because now they know who we are. Maybe it won't, but I know that if I go to trial, if I didn't get any information in the depo, I'm certainly going to get it at trial. And I also know who the defendant is and what kind of person he is. And I know they're afraid of me. But again, I'm not necessarily worried about them being afraid of me. I shouldn't have said that. What I really meant was they know that I know what I'm talking about. Whether they're afraid of that or not is not my problem. But that is the unintended, the secret reason behind depos and why I tell everyone in my firm and in anybody else who will listen, notice the depos immediately, early. Don't wait for documents. Don't wait for delays. Don't accept the defendant determining when you're taking the depo by delaying for months, waiting for times and dates for them to give you. Notice it. Do not take it off calendar until they give you another date that's close in time. Take the depo. Get in the fight. It will change your practice. If you want to know more about this, I got it all on my YouTube channel, AlderTalk. It's in social media, and I've written about this extensively in my Trial Lawyer's Bible. If you want it, just reach out.